Let's now move to the judgment that was delivered this week, because there are some material elements that are really up for discussion. This is the real nub of our discussion this evening. One of the early observations of Mr. Justice Robin Knowles was this. He said the agreement, the contract between Nigeria and P&ID was a mere 20 pages long. And he was astounded by this, to say a contract, oil and gas contract, with such financial implications, such that it contained a liquidated damages clause, that in the event of a breach, that P&ID will be entitled to recover the money it would have made over the 20-year life of the contract, which, as the tribunal found, amounted to $6 billion US. The judge was shocked that it was a mere 20 pages long. And that caused him to think that the problem was that we didn't have lawyers in Nigeria of sufficient skill and experience to be able to match the lawyers that P&ID brought along on their side, which, of course, you and I know is a nonsense. We are where we are for deeper political reasons. Here's another interesting passage. It said that on the face of things, a dispute followed, and then an arbitration to resolve that dispute. The result, according to the decision of an arbitration tribunal in 2017, was that Nigeria owed the other party US 6.6 billion, a sum so vast, I'm quoting him, a sum so vast that it is material to Nigeria's entire federal budget. With interest at the rate awarded by the tribunal, the amount now exceeds 11 billion US dollars. That is how massive our exposure was. And this is what I believe was a major influence on the decision that we ended up with. They simply blinked at that point to say the political fallout would have been unmanageable. And he almost confesses to the political dimension, because he says, but this is a highly unusual case, although one that draws attention to matters of wider importance. Quite apart from the consequences for the parties, the matter touches the reputation of arbitration as a dispute resolution process. That's how big this case was. Even with the judgment as is, the impact that it will make on the whole practice of arbitration, international, not just Nigeria, is huge. This is why we've got to have this discussion this evening. You get a flavor of the implications and the embarrassment for us as Nigerians, because the judge, one of the points that the judge flagged out was that P&ID pointed to what it said was evidence of what it termed catastrophic incompetence. Catastrophic incompetence, both individual and institutional, that it was all pervasive, this incompetence. But a real turning point in the judge's decision was this, that there's a principle in law that the advice that we lawyers give to our clients is confidential. It is protected by the concepts of legal privilege. It means, let me break that down for you. Whereas in litigation, the fundamental principle is that everybody puts their evidence on the table. Even before you get to courts, you produce a list of the documents that you have in your possession. Your opponents will produce a list of the documents that they have in their possession. And it doesn't matter whether the document is in support of your case or is against your case, you've got to disclose. That's the principle of disclosure. You've got to put it on the table, because if it is found out later that you fail to disclose a document, then your your victory could be overturned if the document that wasn't disclosed turns out to be material. The exception to that principle of all cards on the table is, of course, the advice which your lawyer has given to you, because it's your lawyer's responsibility to help you to understand the strength and weaknesses of your case, so you can make a judgment as to how far you want to push it. And if there are weaknesses, we as lawyers will flag it up. The last thing that you want in those circumstances is for my assessment of the strengths and weaknesses of your case to then end up in the hands of your opponents, so they can sit back and review. So, oh, I see. So they're really not confident on that line of argument, in which case, let's go for it. It's plain common sense. What was happening in this case, and this was the major influence on the judge's decision, was that every single letter of advice, every single opinion that the solicitors for the Nigerian government, or the NNPC, were issuing to their clients, thinking it was in confidence, was ending up somehow with the opponents. So the opponents' P&ID were smoking their pipes and reading reading the advice letters. So they knew exactly where to place their feet. Every single document, almost without exception, was ending up on the other side. Now, that is corruption beyond corruption. You know, that is whoever is responsible for it. Anyway, let me say no more than that, because that was what gave P&ID every confidence that they were going to get something out of this judgment. One of the other highlights was the role of the lawyers on both sides. The judge went to the extent of directing that a copy of his judgment should be sent to the Bar Standards Council. That's the body that regulates the conduct of barristers in the United Kingdom, and the Solicitors Regulation Authority, that's their counterpart, who regulate the conduct of solicitors, on account of the conduct of two lawyers acting for P&ID. One was their barrister and the other was their solicitor. And this is what the judge said. Mr. Andrew and Mr. Burke, KC, there used to be QC, is now KC, because of Charles. Mr. Andrew and Mr. Burke, amongst others, have very significant personal interests in this matter. They may have a claim to what were described by Mr. Howard, KC, as, quotes, life-changing sums of money, contingent upon success for P&ID in this matter. The figures are up to £850 million in the case of Mr. Burke, KC, and up to £3 billion in the case of Mr. Andrew. Now, Mr. Andrew was the solicitor for P&ID. Life-changing sums of money. That's how close we came to handing over $3 billion US. Well, in fact, it's £3 billion, the judge said, in the case of Mr. Andrew, and £850 million in the case of Mr. Burke, KC. Amazing, absolutely amazing case. And part of the reason why the judge took that line was that, as he explains, that when I refer in this judgment to P&ID retaining Nigeria's internal legal documents, I mean its choice, rather than returning the documents immediately and unread, to read them and to take the benefit of the information they conveyed. P&ID's improper retention of Nigeria's internal legal documents received at various points during the arbitration enabled P&ID to track Nigeria's internal consideration of merits, strategy, and settlement during the arbitration. That was serious professional misconduct on the part of P&ID's lawyers. And it was the critical turning point as far as the judgment was concerned. That is what the case turned upon. But the judge, as I said, had criticisms for Nigeria's lawyers as well. Here's an extract. Of course, P&ID's position was that it had claimed repudiatory breach. Let me explain that concept to those who are not lawyers. If you enter into a contract, you can, if one party makes it clear from their conduct or from their communications that they are not going to fulfill their part of the bargain, that is treated as a repudiation. They are said to have repudiated the agreement. So P&ID was saying that because the Nigerian government had failed to deliver any gas, that was a repudiation of an agreement that was supposed to have run for 20 years. So reading on from the judgment, of course, P&ID's position was that it had claimed repudiatory breach by Nigeria for the fact that Nigeria had not complied with its obligations under Article 6 of the agreement. But the argument for Nigeria saw no reference to the question whether Nigeria could as readily have claimed repudiatory breach by P&ID for the fact that P&ID had not complied with its obligations. So the judge is saying, yeah, P&ID have run this repudiation argument, but it was open to Nigeria's legal team to say, well, hold on a moment, you're the one in repudiatory breach because you haven't even, the land which you were supposed to have acquired, upon which you were supposed to build the plants, the gas processing plant, you hadn't acquired the land, let alone built the plants. So therefore, you weren't even in the position to receive any gas that we were ready to supply. So there's a judge pointing out, so Nigerian legal team missed these submissions. The hearing saw no discussion of the question whether the law of contract today would treat this situation in a different way to simply asking itself, who asserted first that they accepted the other's failure? So the judge is saying, there were failures on both sides, and it would have been open for us to have countered to say, well, no, you're in repudiatory. But as he said, but it is not for me as a judge of the courts where the parties have chosen arbitration to resolve their dispute to decide the merits of the dispute. That task and responsibility has been given by them to the tribunal. And I'm also acutely aware of the distinction and experience of the tribunal in this case. But I do have to look at what was argued and what was not argued, because this is said to have been affected by corruption, including of Nigeria's lawyers. Nigerians, we've got a problem that if we have, this is a judge of the English High Court expressing concern that arguments may not have been run because it is possible that those arguments were not run because lawyers had been corrupted. This is a serious state of affairs. He went on to say, if the tribunal had known of bribes around the time of the agreement, the entire picture would have had a different complexion. And so too, if the tribunal had known that Nigeria was not, during the arbitration process itself, enjoying confidentiality of advice within the legal professional privilege to which it was entitled. So here's a judge almost excusing the decision that the tribunal came to, that the tribunal did not know about these bribery and corruption that was flying all over the place. because that hadn't been raised as an issue to begin with, and it only became an issue later on. There's another passage that our lawyers need to reflect carefully upon. He said, as before, it is not for me as a judge of the courts to decide the merits of the dispute, where that task has been given to the distinguished and experienced tribunal. But again, in the present case, when I look at what was argued and what was not argued, I struggle to accept what happened in a dispute of this importance and magnitude. This is even allowing for the fact that the tribunal was entitled to rely on the party's professional legal representative to take the points that their clients wished to take, and even accepting that the conduct and efforts of Nigeria's government, administration, and lawyers at this quantum stage of the arbitration was deserving of severe criticism. Let me explain that. The tribunal first decided on whether Nigeria was liable. That's called the liability stage. And it found that based on the repudiatory breach argument that P&ID were running, that we were indeed liable. There was then followed a hearing on the damages, quantum, the amount of damages to be awarded. And you recall that what P&ID was saying was that they were entitled to all the money, all the profit they would have made had there been no breach and had the contract run for its full 20-year life. And that's what they were awarded. Some calculation, abracadabra calculation by experts saying that this is how much they would have made if the contract had run for the whole 20-year period. That's how they arrived at the $6 billion US. Now, it's elementary for lawyers that when you have a situation of a claim for damages, that the immediate principle that jumps to your head is the duty or the obligation on the part of the person claiming the level of damages to mitigate their loss. And so it's not possible to simply come out and demand the profits I would have made for a 20-year period when you hadn't even got started, that there will be scope to attack the figures that their theoretical experts will come up with in terms of the profit I would have made when you hadn't even got started. And this is what the judge was flagging up, that questions that ought to have been put to the other side's experts in terms of their damages quantum claim, that our representatives, our lawyers, missed the opportunity to make those points. The judge, this is what the judge specifically said: there does not seem to have been argument and consideration of argument whether over 20 years profitability might deteriorate for reasons not concerned with Nigeria's compliance with its obligations. So yes, the contract may have provided for it to run for 20 years, but who's to say that you will have made a constant level of profits over the 20-year period? There will have maybe issues elsewhere in your commercial operations that might affect that. And so that would have to be, but if the questions are not asked, if the challenges are not raised, when the experts stand up there and give their expert evidence that in their opinion, this is the profit that would have been made, then you end up paying the full bill. And the judge continued, or save perhaps at 395, which again contains points of law and fact that Nigeria did not test. Note also of the possibility that P&ID might, at least in time, have devoted profitably elsewhere the time and energies it would otherwise have had to devote here. The point the judge was making was this: who's to say that P&ID will have stayed in this line of business for the 20-year period? They may have diversified elsewhere. He says these are points that were not taken. These might test conventional legal opinion and be unsuccessful, but they were not attempted in circumstances where so much turned on it for both parties. So that was his criticism. And he went so far as to mention the fee. I mean, read it for yourself. I'm not making it up. The fee that Nigeria's, the barrister, the SAN, acting for Nigeria, I think Ayorinde is his name, the fee that he stood to make, his fee for the arbitration hearing was a figure of 200 million naira, which is fine. We all know the fate of naira at the present time. But more spectacularly, his fee for negotiating the settlement, out of court settlement, was going to be a staggering $197.5 million US. I say that figure again, $197.5 million US. Oh, Nigerians, we are bleeding on all fronts. Bleeding domestically, we're bleeding internationally. Everybody's simply taking their pound of flesh. And it was these kind of issues, crazy amounts of money, poor legal representation, serious professional misconduct that led the judge to say, regardless of my decision, I'm quoting, I hope the facts and circumstances of this case may provoke debate and reflection amongst the arbitration community and also among state users of arbitration and among other courts with responsibility to supervise or oversee arbitration. The facts and circumstances of this case, which are remarkable but very real, provide an opportunity to consider whether the arbitration process, which is of outstanding importance and value in the world, needs further attention, where the value involved is so large and where a state is involved. The risk is that arbitration as a process becomes less reliable, less able to find difficult but important new legal ground, and more vulnerable to fraud. The present case shows that having, as here, a tribunal of the greatest experience and expertise is not enough. Without reflection, in a case such as the present could happen again and not reach the court. Let me explain what he meant by it. As I've said earlier, the rules and the practice of arbitration is strict. Once you choose arbitration to resolve your disputes, you're stuck with the consequence unless you can scale the hurdle of showing that something has gone so badly wrong that there's been a serious irregularity that will result in substantial injustice. So you can see the thresholds are higher. Serious irregularity resulted in substantial injustice before you can get the courts to look at it. And even in the AMCON case that I referred to earlier, where there was serious irregularity and substantial injustice, where we lost $6 million US, think what that could do for some of our people casually. But we couldn't get through to get the court to look at it. We couldn't get through. So many cases like that are in the system and will never be caught. This one was only caught because of the political pressures that were applied. The figures were just too huge. And you can see that in the judge's comments. He said it was a complete imbalance in the contributions of the parties that enabled the agreement to be in the form that it was. Many reading this judgment will recognize that although in the present case, bribery and corruption were behind that imbalance, it happens in other cases without bribery and corruption, but simply where experience, expertise, or resources are grossly unequal. This underlines the importance of professional standards and ethics in the work of contract drafting, including in the approach to other parties to the proposed contract. Now, I almost laughed there because you see, our problem is not that we haven't got lawyers who are good enough to make sure that Nigeria's interests are properly protected. That's not the problem is the general corruption in the country. which means that we don't always get the round pegs into the round holes. Briefs are given on the basis of relationships, connections, and then everybody, when it all goes wrong, we're lucky that this one was caught. But so many, as the judges hinted, so many are not. And it is, ironically, a legacy from what's the learned judges people handed down to us. It's part of the problem with Nigeria. I'll come back to that later on. This is said, he was so outraged, his comments. I mean, this is why I picked up the comment. He said, notwithstanding Nigeria's allegations, I have not found Nigeria's lawyers in the arbitration to be corrupt. So let me explain that. The only way we got to this point where we were given permission, we were given an extension of time, and we were given an opportunity to show that there had been fraud right through this process. Part of the reason why the earlier judge, Judge Cranston, had been able to find in our favor was that our government had to turn on its own lawyers and allege that they had been corrupted by P&I, such that arguments that they could have run were not run. That was the case that we had to present. Can you imagine the embarrassment? An English judge hearing stuff like that, so that your own lawyers who are supposed to be acting for your country are scoring own goals deliberately. And at this hearing, so we established a prima facie case that this was what was going on. This was now the substantive hearing. The judge said, I'm not prepared to find on the evidence that's before me that Nigeria's lawyers were corrupted. But it went on. So he said, I have not found Nigeria's lawyers in the arbitration to be corrupt, but the case has shown examples where legal representatives did not do their work to the standard needed, where experts failed to do their work, and where politicians and civil servants failed to ensure that Nigeria as a state participated properly in the arbitration. The result was that the tribunal did not have the assistance that it was entitled to expect, and which makes the arbitration process work. And Nigeria did not, in the event, properly consider, select, and attempt admittedly difficult legal and factual arguments that the circumstances likely required. Even without the dishonest behavior of P&ID, Nigeria was compromised. And this is the final comment that the judge made. He said, and Lord Wolfson Casey, that's the barrister for P&ID, will forgive my quoting his submission for his client in oral closing arguments. Section 68 is not there to give you a remedy if you instruct an honest lawyer who makes a mess of it or doesn't take an available point. That is just tough. You have made your arbitration bed and you lie on it, blunt and correct, but unless accompanied by public visibility or greater scrutiny by arbitrators, how suitable is the process in a case such as this, where what is at stake is public money amounting to a material percentage of a state's GDP or budget? Is greater visibility in arbitrations involving a state or state-owned entities part of the answer? So what he's saying there, you see, is that this P&ID case has crashed the fundamental principle of the arbitration system, which is the secrecy and the privacy in which hearings normally take place. You normally do not get to hear what has happened. That's why a big part of why big commercial players choose arbitration rather than litigation. Litigation is a public hearing. Arbitration is private. But because of what has gone on in this case, the scandalous matters that have been unearthed and revealed, where we were at the risk of losing such substantial sums, even the English judge is calling into question whether this principle and practice of arbitration is sustainable. Let me now deal with the fallout. from this judgment. I return first to Segun Adeniyi's article. He said, whatever the eventual outcome, we can take certain lessons from the unfortunate saga. One, we must put in place a well-articulated national arbitration policy. Two, all pending arbitrations should be reviewed with special attention to the ongoing International Chamber of Commerce case in Paris concerning the Mambilla hydroelectric project. Finally, we must institute measures to ensure that Nigerian public officials who sign contracts on behalf of the rest of us do not sell the country cheap, tying us to scandalous obligations after trading away the jurisdiction for arbitration in case of legal redress is the kind of action that would normally attract capital punishment for erring public officials in some countries. Overall, if there is anything that the P&ID scam has exposed, it is that in the Nigerian deep state, there exists a corps of bureaucrats who specialize in misleading political leaders on technical contracts for their personal gain. The minimum responsibility of the Tinubu government, therefore, is to expose and prosecute all the traitors who abuse their fiduciary duties to the country for illicit gain. Charges should also be filed against the foreign scam artists at P&ID to deter those who have made a career of duping our country. Beyond that, we must begin to build a new culture of ethics in the Nigerian public space. Now, those were his conclusions, but these are mine. It is important to remember and keep in mind that this $11 billion near miss was on top of the $16 billion that the Obasanjo administration had squandered with no end product on solving this very same power problem. You see, this thing is an albatross around our necks. Sir Robin Knowles, in his judgment, said, P&ID's improper retention of Nigeria's internal legal documents also allowed it to monitor whether Nigeria's communications. And he pointed out that the permanent secretary had added a note to the Minister of Petroleum Resources on 7th of May 2015, which included this warning. Without prejudice to legal arguments, one of my concerns on this matter is that Process and Industrial Developments, P&ID, is just one of the companies with such liabilities. Former Minister Lukman signed agreements with 2 investors, whilst the current minister has signed with 6 investors. In Nigeria, an extremely good initiative has been undermined by unintended circumstances. Making wet gas available for power generation has become a sore vexed matter as production is constantly compromised and thwarted by vandalization. Despite the huge resources at Egwin, Afam, etc. power plants, domestic power generation is at the mercy of uninterrupted supply of gas, which cannot be guaranteed. Nigeria has become aware of the fact that the tribunal and Nigeria were being deceived. And Sir Robin Knowles made this case has sadly brought together a combination of examples of what some individuals will do for money, driven by greed and prepared to use corruption, giving no thought to what their enrichments would mean in terms of harm for others. Others that, in the present case, include the people of Nigeria, already let down in so many ways over the history of this matter by a number of individuals in politics and administration whose duty it was to serve them and protect them. My people, this case has shown a total systems failure. Every arm of the Nigerian state was compromised. The president at the time, Yar'Adua, did not know anything about the contract. The person who was in charge of public procurement for contracts of this magnitude, according to Segun Adeniyi, did not know about it. The public, we the public did not know about it because it wasn't publicized when the contract was entered into. We the public would never have known because the secrecy rules for commercial arbitration had provided, if it had run its normal course, that it would all have been done and dusted in private. When you read the case, you'll see how every department of state, every arm of government was compromised along the way. P&ID, the briefcase company that had no office, no employees, not even a website. The fellow, the director of it, he started making his money where? It was contracts with the Nigerian police force, similarly inflated. The army also, he had contracts, or they had contracts with the army, similarly inflated. A state governor, the River State governor at the time, was the one that had allocated land to P&ID, which P&ID never ultimately paid for. Attorney generals, former attorney generals were involved in this scandalous exercise, this whole saga. In-house legal team. You may have heard in the press that the woman in question died just, was it the other day or last week or so? She was the one who was their principal conduit for the bribery. So even the external legal advisors ended up with a cloud over them in terms of what was going on. That's advice letters, which were supposed to be confidential, were ending up with the enemy camp. And then we had the international arbitration system itself that casually allowed this company to be awarded $6 billion for contracts that never got off the ground. And they got to the point of rejecting our submissions as to why this contract should not be enforced. We were saved by just the skin of our teeth. The conclusion is this. You see, we have a country, or we've been handed a country, Nigeria, which belongs to everybody. But the problem with something that belongs to everybody is it belongs to nobody. You remember the line that Buhari used in his campaign, I belong to everybody, I belong to nobody. That is Nigeria. Because it belongs to everybody and nobody in particular, it is open season for all sorts of crooks and unprincipled people. They're the ones who will be screaming one Nigeria with the loudest voice. We have to, we can't just say the problem. What is the solution? This is where the Fatherland Group comes in, the work that we've been doing. We have to restore ownership. We have to. Nigeria is not owned by anybody in particular. It belongs to everybody. So nobody is really taking care. The ones who are driven by money and what they can get out of Nigeria, they are getting on with what they do. They're the loudest cheerleader for carrying on the way we are. But those who are genuinely concerned for the interests of their people, they will understand that we need ownership. And what Fatherland has recommended is not the breakup of Nigeria. We're not secessionists, but we believe that we have the brain power to remold and remodel the union in a way that will give ownership to each ethnic group while sharing the Nigerian skin. That's what we called the Orange Union. The skin wraps us all, but each segment belongs to an ethnic group, as we were before Nigeria was constructed over us. So Nigeria remains, but within that, ownership, because it's from ownership that you get accountability. Where you have this massive structure that belongs to nobody, the crooks, they see us from a mile off. They know how to play one against the other. How do you have a contract like this, $6 billion US? And the president at the time, according to Segun Adeniyi, did not know about it. It tells you that there's a deep state in operation filling that vacuum because we don't have ownership. If this had been the resources of a particular ethnic group, and any member of that ethnic group had misconducted themselves in any of the ways that the evidence in this case has brought to light, you know what would happen to those ones. They'll know what would happen. So we've been helped by this case. We have to give thanks. It is a turning point as far as Nigeria is concerned. A highly significant case. If the international arbitration system is under review because of this P&ID case, arbitration lawyers across the globe, and it's a global industry, will be reading this case as a point of reference. We've got to fix up, because the lawyers who are reading those cases, they will be the heads of legal departments in the kind of companies that we're trying to attract investment from. And this case has exposed so much.